Birdwell,
Present.
Senator Hinojosa,
I believe Senator Hinojosa is going to be about 15 minutes late. He had a conflict, but wanted to be sure that everybody knew he will be here.
Senator Huffman, Senator Nichols, Representative Hunter,
Here.
Representative Landgraf,
Present.
Representative Nares,
Morning, present.
Representative Sherman,
Here.
Mr. Babcock,
Present.
Judge Jameson, Chief Justice Jefferson,
Here.
Ms. Liberato, Mr. Oliveira, and Chief Justice Phillips.
Okay, we have a quorum. Thank you, Megan. Our first action item of the adoption of the minutes of our August 7, 2020 meeting. I assume everybody's had an opportunity to read those. Do I hear a motion that those minutes be approved?
So moved.
All right, it's been moved. Do I hear a second?
Second.
All right, it's been moved and seconded. All those in favor of adopting the minutes as they currently read from our August 7, 2020 meeting, please say aye.
Aye.
All those opposed, same sign. The motion carries. All right, we're fortunate to have a number of people to appear before us this morning. And our first speaker is Rob Henneke, who's General Counsel of the Texas Public Policy Foundation. We received a submission by the foundation earlier this week, and so we thought it might be appropriate to have Rob Henneke appear and expand a little bit on his filing. So with that introduction, Rob, the program is yours.
Well, thank you. Thank you, Mr. Beck, members of the commission. Good morning. Again, my name is Rob Henneke. I'm the General Counsel of the Texas Public Policy Foundation. I want to thank you all for accepting the comment that we submitted and the invitation to visit with you. I think to expand upon where the foundation's coming from, we felt that it was important to submit the comment in order to be on record in supporting the purpose of this commission and what you all are pursuing and considering. That, you know, there are problems with the way that we're selecting judges in Texas, and that at the foundation, we believe that alternatives have merit, and are worth discussing and debating. Specifically, the foundation, you know, is supportive in concept of the idea of a appointment type system in replacement of a direct election system that currently exists. I think as you see in our comment too, we recognize that already Texas basically has a de facto hybrid type system where you look at the fact that, recent history, the percentages of Supreme Court, appellate court, district court judges that are appointed by the governor and confirmed by the Senate are, very large percentages, over 50% for the appellate courts. I think over a third for trial courts. And, in the situations you've had, outstanding men and women who have been chosen by the governor, who have gone through Senate confirmation and, served with distinction as a member of the judiciary. So there's proof already that this can lead to good results. And certainly we have concern in the way that, in large parts of Texas, the way that judges are being selected to serve as members of the judiciary have little more to do than just the letter that's next to their name, or sometimes, a public response to a particular name without knowing anything about that candidate. And that's leading to results that don't do justice in Texas. And I think it's also leading to the increasing polarization and partisanship of the judiciary, where that is not the proper role or purpose of that branch of government. So we do not have a specific proposal that we are in favor of. I think it's premature to do that. We mentioned in our comment a couple of areas that we would have concern with, but more so just wanted to be here to be on record as saying that this is worth pursuing, and this is worth addressing for the betterment of Texas. The last thing I would say in closing, before certainly entertaining any questions or discussion, is that the foundation does believe that you need to make sure that any system that's recommended or moving forward has the direct control of elected officials, of officials who are accountable to the voters. If you're going to move away from a direct election type system, then I think essentially what we have, this hybrid model here today, shows accountability. It shows checks and balances, and shows a process for selection of great men and women, and we want to keep that tied to where there is accountability, because I think that'll protect the integrity of the judiciary now and in the future moving forward.
Mr. Hennigan, this is David Beck. A couple of questions. I know you, in your submission, were critical of nonpartisan elections, and you were also critical about the so-called Missouri plan, where you basically have a commission that comes up with candidates and submits those to whoever the appointing party is, usually the governor. And I wonder, I mean, is there any particular method that you're aware of that the foundation would tend to lean toward? I know you're not endorsing anything, but and we're going to have a difficult choice to make. We not only have to evaluate all these various alternatives, we've got to make recommendations to the legislature. So any help you could give us, and as far as what you would prefer in terms of an alternative, would be helpful.
Yes, sir. Thank you for that question. I think what we would prefer and be inclined to support would be a codification, essentially, of the nomination confirmation process that currently exists when there is a vacancy that occurs in the middle of a term, where it's working through the governor's appointments office. The governor nominates a candidate that's vetted internally by the governor. And then, of course, that candidate during the next session, it has to go through Senate confirmation with the nominations committee, the committee hearing process, and then ultimately a vote on the Senate floor. I don't think it has to be more complicated than that. And, where I think we would have concerns is where you would create separate bureaucracies of commissions or private parties that would have, influence over the selection or the process, that it isn't directly accountable to the people. That's a big problem with the Missouri plan, but there's other examples that are out there where you kind of lose the control and accountability when you delegate that to third parties. So I can kind of point that as examples of what I don't think would be good. But the simple way to answer to your question, Mr. Beck, is to look today at the status quo of how this hybrid system works, and I think works well and has a proven track record of accountability, checks and balances, and also of selecting outstanding jurists as a simple way that already basically fits within the process and could be pointed to as a proven workable alternative to the system of direct elections.
Thank you. Members of the commission, any further questions of Mr. Hennigan?
Yes, Mr. Chairman, Senator Birdwell.
Thank you, Senator.
Mr. Hennigan, thank you. Have you done any enumeration of there are governor appointments, but there are a chunk of those appointments that get to the Senate and there's a chunk of those appointments that don't get to the Senate because the nomination of the governor makes that new judge the sitting incumbent, and the people of that geopolitical subdivision the judge is now the incumbent upon vote on that individual before Senate confirmation. Simple example, my brother Wade was appointed by Governor Abbott to go from the district bench to the Second Court of Appeals in Fort Worth. I didn't get to bring him in front of nominations. That would have been very interesting. But how many of the judicial appointments actually make it to the Senate? And how many of those have you looked at the last 10 years to see what that bifurcation is, where the Senate confirms, or because there's an intervening election before the Senate convenes, the people in that geopolitical subdivision have confirmed via the vote? And the other question would be, are there any nominees that were appointed by the governor that were rejected by the voters, say in the last 10 years?
So,
Go ahead.
no, thank you, Senator Birdwell. The point is well taken. I've not done the math to break that out, but I would agree that if Texas moved to, I guess, codify a nomination confirmation type process, then I think that could be beefed up. I think that could be improved, and you could look at the Senate having to convene in the interim to confirm judges before they would be seated or something like that. Whereas you're right, under this system, the appointments are not really designed to be the way that judges are selected. We have an election system, but that's just become the default for the majority of appellate courts and a third of the trial court. So I think
do you know how often the Senate has called appointed judges to the nominations committee in the last 10 years?
I don't, but I do agree that that current process appears to be, relatively, not as rigorous as I think it would be should we move and solely rest on that basis. And
just using my own experience as chair of nominations, it is difficult. The governor has what both Governor Perry and Governor Abbott would average around 400 to 500 nominations that the Senate has to sit in judgment of each 2-year biennium. The numbers of people that we would have hearings on that we would, I'm just giving you my experience so that you understand the size and scope of the challenge that you're talking about here. Is we ran in fact, in the 17 session, which was my last session to chair nominations, we had, I think it was 405 nominees, and I'm running off memory here. So I'm in the ballpark, I'm in the foul lines, but this is not exactly right. But we had 405 nominees. I think we rejected 4. But out of that, when you look at a hearing a week with about 4 people per hearing, I had to average about 35 people that were before the committee as a nominee, 4 of which would appear. 31 their appearance would be waived, because you've got, boards of regents, you've got water development board, secretary of state. There are over 4,000 appointees that the governor has. What I'm trying to make clear here is that when I chaired nominations in both 15 and 17, I had a singular hearing somewhere in March or April of both sessions where I brought in judicial nominations. I brought in a district judge, an appellate judge, a regional presiding administrative judge, So I'm trying to get each of the types of judges that we have. Plus, I brought in a judge, not in their capacity as a judge, but they were a judge that was sitting on the Judicial Conduct Review Commission. So what I'm trying to say is the scope and the size of the totality of the nominees that are before the Senate, unless the chair, as I did, makes it a point to at least be rigorous for a portion of what you've got. But there were lots of judges that the governor appointed that I didn't bring in because of all the other things that I'm looking at across the other nominees that the governor's appointing. I don't know that you mentioned having, I don't call it a special session, but how do you do nominations that would require some sort of a constitutional amendment to allow the Senate to do nominations when we're not in session? Point is that numerically that would be a significant challenge to address. So that's why I was looking to see if you had numbers of how many actually culminate and come to the Senate, and how many do the citizens get to actually sit in judgment of before the Senate does.
No, I don't. I think that's worth looking into. And I do think if you all moved in this model, essentially each of these nominations would be like local bills, Senator. And I think, one of the differences would be the increased input and involvement of all of the members of the Senate, where they would certainly have an active opinion on, potential nominees that would overlap with their district and so forth. I haven't done that math, but I want to answer just briefly the other question that you had in terms of judges who had been appointed and then subsequently unelected. There are several examples, but I think those kind of make the case. I mean, for example, you had Judge Xavier Rodriguez, I believe was Governor George W., Supreme Court jurist who was defeated. Perry. You had Judge Medina. Here recently, a number of the appellate court justices, I believe Justice Bland was originally appointed to the Houston Appellate Court, and then she lost in 2018, subsequently appointed to the Texas Supreme Court. So, in these situations, you do have those examples, but I think a lot of the examples point to kind of the lack of where the decisions seem likely to be, not because of the merit of the jurists, but because of other factors that contribute to them being removed from the judiciary. And that in some ways makes the case and the point of what you all are evaluating through this commission.
Thank you, Mr. Henneke. Thank you, Chairman. Sorry I went a little long, but I
No problem, Senator. The question I have of you is, would you like us to try to accumulate some of the data that you identified?
No, let me talk to Peggy Venable. Peggy will be able to do that. And then the committee director, Robert Haley over there, can give me some of that historical background as well. Because there's many of the judges that the governor has appointed will sit before an election before they come to the Senate. And that's why the question about how many people were appointed and in the immediate succeeding election were rejected. It's one thing to be appointed 10 years ago and then eventually be rejected, but were they rejected by the citizens in the immediate, not proceeding, but the immediate election directly succeeding the appointment? I don't know if there's any examples. There may be out there historically, but I can chase that rabbit. You don't have to chase that.
Okay, well, thank you. We have exactly that situation in Harris County, where the governor 2 weeks ago appointed someone as district judge, and of course he's running for election now. He had earlier been on the bench, was defeated, has now been reappointed, and now he's running again. And so the Senate will not have passed on that. So anyway, thank you, Senator.
Thank you.
Any other questions from any
Yeah,
other
yeah.
commissioners?
Yes, Mr. Chairman. I anticipate a criticism of the proposal that you have advanced would be from the party who's not in the same party as the governor. So it seems, pretty clear that a governor would appoint primarily Republican judges and not Democratic judges, and the recent elections where Democrats have begun to win election, they would say, well, you're going to take that possibility away. And when you do, it also makes the judiciary less diverse. What would you say to that anticipated criticism?
Well, thank you, Justice Jefferson. I would say that I think that the involvement of the Senate in the confirmation process would actually lead towards greater diversity, and much as the Senate is involved in nominations from on all the numbers that Senator Birdwell mentioned, that the way that the Senate operates, of course, I think it would have to be yet to be determined by what vote majority it would require to confirm a judge, but that the process would naturally be one where in the totality of the operation of the legislature, the Senate, and its interactions with the governor, that Senator Hinojosa, Senator Birdwell, each of the senators would have quite a bit of influence and say so on the jurists who would be appointed from their district in a particular area. And I think that would, lead to diversity of all types, but also in the buy-in of the members, and also, to ensure that, those candidates would be ones that would be supported by the Senate. I mean, as I mentioned earlier, Justice Jefferson, I mean, to me, it's kind of like a local bill. And, the way that the Senate operates is if you have strong opposition by a member of the body for something that's local within their district, usually it's pretty hard to move that, given the way that the Senate has always operated. And I would expect, without even having to codify that you would see that in the same type of operation where, if there was a judge that was nominated in Senator Birdwell's district, and he really didn't like that judge. I think it'd probably be unlikely that judge be nominated in the first place, but I also think it'd be pretty hard to move that judge towards a confirmation vote in the Senate. So I think that would sort its way out, just in the same way that other types of legislative proposals are worked out amongst the members.
Well, we have a history. Every judge appointed by Ann Richards to the Supreme Court was a Democrat. Every judge appointed by Bush and Perry to the Supreme Court was a Republican. And so it seems like the system that you're advocating would make it less likely for there to be a bipartisan judiciary in the state. And just looking at the record of gubernatorial appointments in the past, well, forever. And I think that would be something that the commission would have to deal with, that sort of criticism of that proposal.
It would have to be addressed, I agree, but I also hope that the result would be ones where, the partisan affiliation of the Supreme Court justice or appellate judge would be hard to determine, because you would be picking, outstanding and highly qualified men and women who would discharge their duty to interpret the law neutrally and apply it to the facts of the case. And so I think that would be the goal, and that could be the greater focus in the confirmation process if you set aside the dependence on partisan elections and outcomes.
Thank you.
Mr. Chair. You're muted, David.
Any other questions by members of the commission?
Yeah, I have one if I can
ahead.
be recognized.
Sure,
Thanks.
go ahead.
Mr. Henneke, I wanted to ask you a question about transition from where we are today to a new system should the legislature decide to create one. Your letter, which was terrific, and thank you so much for taking the time to write it, is very thoughtful. But you characterized the 2018 election as a wave election, which I think in many parts of the state it certainly was. One of the byproducts of that wave election was that the judiciary is much more diverse now, certainly in Harris County and in Dallas County and others than it was before. What do you think about the transition from where we are now, where we have a much more diverse judiciary, which I think everybody on the committee would be in favor of, to what you propose? Would you wipe all these? Would you wipe the election clean and knock out all these judges and have everybody appointed, or would you say the governor's got to appoint the incumbents? Or how, if you've thought about it, would you plan for the transition?
It's a great question, Mr. Babcock. And
Well, thank you.
honestly, I don't have an answer on that. I mean, I don't have a way, we don't have a position on how that would work.
Okay, thank you. And thanks for your efforts. Terrific letter. Thank you.
Yes, sir.
So to Mr. Haneke's earlier point about the Senate, I know when the governor appointed me as a regent of the University of Texas system, I had to appear before Senator Birdwell's nominating committee. And before I appeared before that hearing, I had to go and meet with a very large number of senators, both Republicans and Democrats. And the Democrats asked me a lot of very pointed questions, as did the Republicans. And I dare say that had there been a lot of opposition from either party, I would not have ultimately been appointed. But my point is that I had to sit down with members on both sides of the aisle and address very pointed questions before the hearing, before I was ever approved. So anyway, any other questions of Mr. Haneke?
Mr. Chairman, I don't have a question of Mr. Haneke, but I did want to offer a comment of my experience with your comment about being appointed a regent, because you've mentioned something that I think ought to be in the background of the mind of all of our commission members. May I address it, if I may?
Absolutely, Senator.
When I became chairman of nominations, within hours of being named by Governor Patrick, my phone had blown up and I had all kinds of folks asking me for time as the chair, and rightfully so from a courtesy perspective. As chairman of nominations, I chose that, unlike previous chairs, not only did I not have the time to meet with everybody that I was calling in, but what Chairman Beck just fundamentally described to you is that all of the poignant questions that he was asked were in private and not a transparent questions asked in a public hearing. The numbers of times that I brought in, whether it was Board of Regents, other individuals to nominations, more often than I would care to count, I, as the chair, always offered other senators the opportunity, mainly because of the conflicting committee schedule, but offer other senators the opportunity to question nominees that I had decided to bring in, to question them first. And quite often the senator, Republican or Democrat, would say, I've already asked everything I wanted to know, so I don't have any more questions. The problem with that structure is not a single one of those questions was on the record in the hearing for the people of Texas to watch that hearing and hear the answers and hear those questions. So part of the reason I did what I did was for the purpose of making sure that the customer, who are the citizens of the people of Texas, were seeing and hearing and getting a a rigorous hearing so that questions could be asked publicly. Doesn't mean that private meetings are inappropriate. It just means that there's a lot of things being asked of nominees that are not being put on the record in the public hearing. And that's not anything we should ever do, frankly, in my view, with any nominee, but in particular, judicial or district attorneys that the governor nominates in the absence or resignation of a district attorney. So that was why I ran nominations the way I did. So I hope you thought you got a fair hearing, Chairman Beck, when you came before us. I know it was tough, but folks need to have that background because there were a lot of questions asked with individual senators that I think should have been on the record, but weren't.
Yeah. Thank you, Senator. Yes, I did think I got a fair hearing, but there were a lot of probing questions at the hearing too. So,
Mr. Chairman,
Thank you, Mr. Chairman.
if I may,
yeah,
just a
Senator
comment.
Hinojosa.
Thank you. While my dear friend and good friend, Chairman Birdwell, there are also situations where I know just from past experience where there are private conversations, if you will, when a potential candidate or appointee meets with a senator. It doesn't mean that we're not being transparent or trying to hide anything, but it's just a preparation for the public hearing because we may ask some of the same questions. And some may not be appropriate, quite frankly, for the general public. It would be very personal. That's the only comment I would make. And I've been through this process many times before too.
Chairman Hinojosa, I concur that there are things that you have to ask that may not be appropriate. But all too often, the private meeting was in lieu of a rigorous hearing for the public hearing. All too often, I was sitting there by myself asking questions, unless it was like a Chairman Beck or Mike Morath of TEA, because of the conflicts, particularly as you get deeper into session in March, April, and May with other committee hearings. Those private hearings, while there's absolutely, you are correct, my friend, that there are things that need to be more discreet, but all too often those were really what was in lieu of a public hearing.
Well, I don't consider them private hearings, they're just private conversations. And obviously, as you well know, sometimes for us senators, we have, I have 10 committees that I'm assigned to. So it's part of the process and nature of the beast, trying to cover all the committee hearings. But anyway, thank you for your comments, and I will.
Thank you, Senator. I appreciate it, my friend. Thank you.
Yes, sir.
Okay, any other questions from the commissions of Mr. Henneke before we release him? All right, there being no other, Rob, thank you so much for taking your time to appear before us today to expand a little bit on your submission. And thank you again for the submission on behalf of the Texas Public Policy Foundation. Thank you so much.
Privileged to be here. Thank you, Mr. Beck, members of the commission. Thank you.
Thank you. All right, our next speaker is Judge Robert Schaefer from the 156th District Court of Harris County. And I will tell you, as a point of personal privilege, Judge Schaefer has served well as one of our district judges in Harris County. He previously served as administrative law judge, so he not only was dispensing justice in the 152nd District Court, but he also had a very serious and important administrative law position that he held and held with distinction, I might add. So he's been very kind to agree to appear before us today and provide us his thoughts on the current system and any other ideas he may have with respect to alternatives. Judge Schaefer.
Thank you. And thank you for inviting me to participate in this. I really appreciate it. Just parenthetically, Justice Jefferson, the last time a nominee came from a different party for the Supreme Court, I think, was when Governor Clements appointed Judge Ruby Sondock to the Supreme Court to finish a 6-month term. That's probably the last time opposing parties came together in that respect. And that was, I think, in the 1983-84 timeframe. You know, if your goal here is to take politics out of the system for selecting judges, there really is no method to do that. Any method that you choose is going to have political overtones and undertones in it, be it an electoral process like we do, be it a nonpartisan electoral process, be it an appointment process that Mr. Henneke was advocating just a moment ago, or a commission appointment retention election process. They all have political implications and involve politics. So I don't think we can devise a system where you take politics out. If you're trying to devise a system where the idea is to retain institutional knowledge and retain experienced judges for a period of time, there are ways to do that without necessarily changing our system. One way to do that would be to extend the terms for the judges. Another way to do that is to maybe increase the qualifications for the judges. And those would be aspects of our system that would do that. As I talk to my colleagues and others around in the Houston area, though, I have to say that it's kind of interesting how this commission has been developed at a time when the party in power is losing elections to the other party, and it just doesn't look like what you're really interested in is a qualified judiciary. It looks like you're trying to get back positions that you lost because of the changing tide or the wave mentality, like you were speaking of earlier. We've had sweeps in Texas politics since the 1980 election with President Reagan's election. And it's been going on since then, depending on which party prevailed at the polls. And then in the 90s, it became a Republican sweep, and it was maintained through the 2008 election. So I don't really have a suggestion as to what a better system would be. If you ask me personally, what I'd like to see is, I'd like to see an election with retention elections later, but that's somebody who's already in the boat and wants to pull up the ladder, so to speak. And so I don't know if that's the way to go or not. I don't think, really, I appreciate Mr. Henneke's remarks, but I really don't think anybody is really advocating a gubernatorial appointment system because it produces the types of appointments that we've had in the past, and it does lack diversity, and it does require you to be, I don't know if I'd say an establishment person, but someone like me would never get a gubernatorial appointment from the opposing party. Now, I've been on the bench now for almost 12 years, and I think most people would say I haven't embarrassed myself during that time on the bench, that I've shown myself to be a qualified person to serve on the bench. But without these the political type of elections we have, and I'm not proud of that necessarily, but without these kind of elections, people of the opposing side, people of color, people that would qualify as a diverse group just wouldn't be successful in getting selected to these positions. So your charge, I think, or your problem in coming up with a system is how do you retain the diversity that we've got now and try to take politics out of the situation, try to take money out of the situation, and things of that sort. I don't really have the answer to that. I'm sorry if David Beck was asking me to come here today with a solution to your problem. I don't have a solution. I have colleagues who say go to a election retention commission type situation where you get elected and then you have a commission go into the background and see how you've performed over a period of time and then recommend retention or not. Again, the retention election where you do an election. But from my perspective, you're going to have a problem helping people understand why there's this clamor to change now that the other side has prevailed. And mind you, I think the way we select judges is not a good one. And I lost colleagues who I respected tremendously in the 2018 election. But in every sweep kind of situation, what happens is you have good judges taken out, okay judges taken out, and bad judges taken out. And what do you get? You get good judges come in, you get okay judges come in, and you get some judges who might not be okay. It's how we've done it. Quite frankly, I think you're going to have a hard time getting anything passed through the legislature anyway. I'll be quiet now and let y'all ask me any questions you would like to ask.
Judge, thank you very much for those comments. I was making a lot of notes while you were talking. I guess one question I'd like to have, and this really has to do with the optics that you mentioned twice, that there's concern certainly on the Democratic side that, well, why is it now that the Republicans are suddenly interested in taking a good hard look at our system and making changes? But I guess my question is, somebody, whether it's the Democrats or the Republicans, has to start exercising some statesmanship. I mean, it's got to come from one party or the other. And doesn't it make more sense that it comes from the party that's currently in power? I mean, they may be losing elections, but at least they're still in power. I mean, am I missing something?
No, you're not. And I would imagine that Justice Jameson might disagree with you with the comment that you made, because whenever I hear her speak about judicial selection, she brings out that 1988 newspaper article about her father and his advocating the changes in the way that we select our judges. Yes, there should be a discussion, absolutely. And it has to start somewhere. And whether it starts with the party in power, actually, if you're going to have the discussion, it has to start with the party in power. And I don't think anybody criticizes the discussion necessarily. Frankly, I think this is a horrible way to select a judge. I don't mind. I have no objection. I don't mind going out and visiting with clubs and getting petition signatures and that kind of activity, because it is kind of a good idea that you keep connection with folks that are real people, not just the lawyers and the politicians that we see most of the time. But the raising of money is a problem. You know, I like the checks when they come in. It makes it easier for me to do things that I feel like I have to do in order to get elected. But it is uncomfortable. And I have sent checks back because of the timing of when they come in. It looks bad, but yeah, you're right. It does have to start somewhere. And if we're going to start it today, it has to start with the party in power.
All right, members of the commission, any questions, other questions of Judge Schaefer?
Yes, Tom Phillips, I have several, Mr. Chairman.
All right.
Judge, you mentioned qualifications. Do you have any specific ideas of what could be put in the Constitution or in a statute that might ensure that people come to the bench with the requisite background to be at least an adequate judge from day one?
Well, I think years of practice is something that you can look at. Now, I say that, but you can go back over the past and talk to people who didn't have an extensive amount of practice. And I dare say there was one judge, I think, who sat on the 281st District Court, who said when he took the bench, he had 5 years, 11 months, and 17 days. Did I get the timing right there, Justice Phillips?
Close enough. Yes, and I do get sensitive when people start saying, oh,
right.
It's good.
And
I mean, although I'm thinking that now, but I didn't used to.
Well, and I remember, obviously, I remember you making that comment previously in other conversations that we've had. But with that said, I think generally speaking, more experience is better. You're a different lawyer, and your knowledge is different if you're a 5-year lawyer than if you're even a 7 or 8 year lawyer or a 10-year lawyer. And it does that additional knowledge and that additional experience, I think, does tend to give you more ability to see things and perform better on the bench. Other people have suggested that maybe you have to be board certified in your area of expertise or the area that you're running for. I'm not a big fan of board certification. I've seen a lot of board certified lawyers who I worked with and against as a practitioner and who have come before my bench who I wouldn't hire for any reason whatsoever. So I'm not sure board certification is the way to go. But somehow, I mean, right now we are seeing campaigning where people will bring up the trial experience of a judge candidate, judicial candidate. But I think years of experience is one thing you can do right now. I think you would have to do it through the Constitution and maybe try to find a way to look into the litigation experience of the lawyer might also be one other way.
And then I have one more question. You mentioned that you were for retention elections after an initial election, like Pennsylvania and Illinois and New Mexico have, but you put it only in self-interest terms. My experience has been that if the voters have enough information, they usually will make the right decision. But in the urban judicial contest, we are giving them an impossible burden. I dare say that even the judges at the courthouse don't feel like they're casting an informed ballot all the way up and down the judicial offices. So why wouldn't a retention election after one election, or at least alternating between popular and retention elections, be a way to give more stability to the judiciary perhaps, and a ballot that the average voter would have a better chance of succeeding at?
Your point is very well taken. In the 2018 election in Harris County, the voters voted on 76 judicial positions. There is no way I could be knowledgeable about all 76 of those positions, and I'm in the system. So the difficulty is enormous. You add to it now the fact that there's no straight ticket voting. And so we're now relying on people to go to the bottom of the ballot. And that we're looking at possible voter fatigue as well. I think I made a bad joke about it, that it was a personal preference, but I do think retention elections probably are a better way to go to once you go through a partisan political election and get elected to the bench. And I think if you talk to most of my colleagues in a closet where there's no recording devices handy, they might agree with that.
All right, any other questions of Judge Schaefer?
Yes, Chairman.
Sorry, Chairman, who'd you call on? Senator?
Senator Birdwell.
Okay.
Mr. Chairman, am I recognized or?
Yes, yes.
Oh, okay. I didn't hear. I'm sorry.
Yeah.
Judge Schaefer, thank you for joining us this morning. How would a retention election change? You mentioned 56 judges or 70, was it 76, I think, that were on the ballot. How would a retention election change that number?
Well, first of all, you're
still functionally in the same situation, correct?
Well, I guess you could say that, but you'd have to take them off the traditional ballot.
Okay.
And put them on a separate ballot.
What would be your thought on having the judicial offices elected in the odd year constitutional amendment timeframe?
Well,
now that brings up the challenge for the primary in the sense of you know, you're having your primary during the odd year, and there may be costs to that. But what if judges were bifurcated from the other elections timeframe and placed in their general election slot at the same time as the constitutional amendments in the odd year November?
That would present a completely different campaign scenario. Obviously, you're looking at a much lower voter turnout. The turnout for a constitutional amendment is what, 3.5% of the voters? And I only say that partly in jest.
Well, it's not quite that low.
Yeah, I know.
Yes,
That's
sir.
why I say that partly in jest. But the truth is, it's a very low turnout. And so the campaign, I don't know, I would probably, just thinking out loud here, I'd have to raise more money and do more campaigning, because then I would, in a general election, I would not be able to run on anyone's coattails. I would have to create my own name identification. And in a county the size of Harris County, I think that if you don't have at least $1 million to spend on a PR campaign, you can't move the needle and you can't get anyone's attention. So what concerns me is that you would be probably having to campaign more for fewer votes and spending more money per voter than you would otherwise spend in a even numbered year election.
Okay. Then let me, good points, Judge, because let me ask this question. It's way outside the box, but let me ask it, because what I really hear from the testimony we've heard is the symptom that I think people are trying to address with some sort of structural concern, structural modification, is too many people on the ballot. And in our larger counties, the media market is too many people to try to reach. You mentioned the number of district judges you have in Harris, or the number that we have in Tarrant or Dallas. Would there be any merit that instead of having those judges specialize as a court, family court, civil court, criminal, what if judges were assigned a regional location within the county, so that your district judge that you're voting for has this geographic area of Harris County rather than the totality of the county? What if you sub-apportioned your district judges in the large urban counties to a geographic area so that you've got a more refined target customer audience?
You would definitely do that, but here's a concern that I would have.
Okay.
If I have a case in my court where it's a medical malpractice case with a doctor who lives in West University Place, which is a bedroom community in Houston.
Right.
And if that doctor comes to court and a jury happens to just hammer the guy and awards a huge verdict against him, and I sign that verdict, then in a smaller district, the doctors can team up and create this pack and talk about the terrible things that I'm doing as a judge to healthcare in Houston. And I'm preventing healthcare, and I sign this verdict and just go to town on me. And obviously, as a judge, I have no way to defend myself against that kind of attack. And I'm concerned that that's one of the byproducts of creating smaller districts for judges to run in. It would certainly give you a more diverse politically and culturally and ethnically and racially, but you would have those considerations that would concern me a lot.
Okay. Thank you, Judge. Thank you, Mr. Chairman.
Judge Jameson.
Thank you. Judge Schaefer, good to see you as always.
And same for me, thank you.
You mentioned your colleagues have thrown out as a possibility the retention elections, but the involvement of a commission that would recommend whether or not they be retained or not. Can you tell me a little bit more about what that idea is about?
Sure, and it's one that I heard from one of my colleagues about 5 minutes before I logged into this. She called me and I said, I'm going to attend this hearing. Do you have a suggestion? And boy, I heard it. Yes, the idea she posed was you run, and instead of a retention election, it's a retention commission made up of lawyers, maybe judges, the public as well, and they review your record. They review the timeliness of your rulings, the how well you conduct a trial, your reversal rate, and things of that sort, and do what she called a real evaluation of your performance on the bench during that 4-year period or whatever period it is that you hold the job. And then that commission would vote on whether to retain you or not. I am not advocating that necessarily, but it was certainly an interesting idea that I heard about earlier today.
Okay, so it's a judicial, instead of a selection commission, it's sort of an evaluation commission, but then there would be no election from the public after that.
Not right. Under the way she described it, yes, there would be no election from the public after that.
And if the commission voted not to retain you, there would be an opening. And so whatever process of selection would have to start there.
Right.
Let me also ask you whether your colleagues have either speculated or have any more feeling about what what's going to happen with the no straight ticket this year, and what are people thinking?
There are those that think that one party or the other will turn out its vote and they'll go to the bottom of the ballot and everything will be great in that respect. I don't necessarily subscribe to that thought. I think there will be some degree of voter fatigue, and I think my colleagues, for the most part, would agree with that. The percentage of it, I don't know. I think the difference between my vote and the top of the ticket in each of the elections that I've been in has been under 10%, but sometimes it hovers right around 10%. I would think that it easily will double and could be more than that. I mean, that's the big concern that I think everybody has, is whether or not people will go down to the bottom, down the ballot. And if I was a JP or a county court at law judge, I'd be really even more concerned than if I am as a district court judge.
At what level are they getting more nervous? You're a little close. You're above halfway down, and so when you get to the 234th or the 333rd, where are people getting more nervous?
Well, everybody's kind of nervous, and you know that because you've talked to people also. Everybody's kind of nervous about it. Obviously, the further down the ballot you go, like I said, if I was a county court judge, I would be a lot more nervous because that's like on page 24 or 25. I think my position usually ends in either the high teens or the early 20s. But even that, I mean, look, I would venture to say most of the people on this call do not vote straight ticket. Okay, and so you know what it's like to actually go and vote all the way down the ballot. And so we have to think about who of the people that we know that aren't as educated about what's going on in the courthouse, whether they will do the same thing we will. And I think everyone is concerned that just won't happen.
Okay. And my last question, my last area is you were speaking about qualifications. And I had thrown this out to somebody earlier. Would there be any benefit to having a course that either a candidate or a judge could complete that would be more germane to the actual job you perform than anything that has happened in private practice, be it years of experience, board certification, et cetera? Is there anything like that, and maybe include implicit bias and some other topics that are important for a judge who might not know that until after they get on the bench. Is there anything like that that would be helpful for either the commission or the public to know that someone had completed?
Well, as you know, when I first got elected, that December before I took the job, I went off to Dallas for new judge school. And that was a 4-day program, which I thought did a really good job of changing my mental focus, because that's really probably the most important thing you can do going from being a practitioner to being a judge. Is that enough? Probably not. In 2008, it probably did not, as I recall, include implicit bias. I would think that in 2020, it probably does. Should there be a requirement that they continue that? I think there's nobody that would object to that. And you know, what we do.
Judge, excuse me for interrupting. My question is, before you're elected judge, as a candidate, would that be a qualification?
It's an interesting thought. I don't know. I'd have to think about that. I'm not sure, as I'm sitting here thinking about it, whether you get all candidates to do it unless you made it a requirement. But I'm not sure that if we did that, if you wanted to make it a requirement to get on the ballot, that's one thing. If it was for some other purpose, it's something else. I'm tongue-tied on this one because that's an interesting idea and I had never given it much thought. Sorry.
Right. No, that's fine. And I wasn't thinking of it necessarily as a requirement, but as a qualification. Someone should say, this is another reason you should vote for me because I've thought about this. Anyway, thank you. And thanks for being here.
Thank you.
All right, members of the commission, any other questions of Judge Schaefer before we release him? Yes, Judge Phillips. I think you're muted.
I've got one more. Sorry, I was muted. Your comments about the evaluation commission intrigued me, Judge, and I recall that a Chief Justice in North Carolina had a proposal like that once. And to keep the commission from being arbitrary and not accountable, his spin on it was that if the commission approved you, thought you were eligible for another term, you went to the Senate and it took a 1/3 vote to be reconfirmed. If the commission thought you shouldn't have another term, you went to the Senate and it took a 2/3 vote to be confirmed for another term. Does that sound like a wrinkle that would be helpful? Or is it just an added burden on that idea?
It would certainly encourage me to take a trip to Austin and spend a few days in Austin wandering the halls of the Capitol. That's an interesting thought. I really don't, as I'm sitting here right now, I really don't have an opinion, yay or nay on that though. I'd have to give that some thought.
Well, it didn't pass there, but it was at least proposed.
Okay. Okay, thank you, Chief Justice Phillips. Any other questions of Judge Schaefer?
Mr. Chair, can I ask a question at this point?
Absolutely. Go ahead, Chip.
Thank you. Judge, nice to see you. I may be only the vice chair of this commission, but I will not take a back seat to David Beck sucking up to you as one of our finest judges in Harris County.
Thank you. Thank you.
I want to be first in line for that. I've practiced in front of Your Honor, and I agree with the chair that you are a terrific judge, and thank you for being here. You mentioned in your remarks that raising money is a problem. You said it's you're uncomfortable, and sometimes you have to send checks back because of the timing. What effect, if any, do you think the way judges have to raise money in our state under the current system affects public confidence in the decisions our judges are making?
I think that the people who look into the issue are concerned about it. I think most people who vote, at least in the major metropolitan areas, don't really know about it. that much. I mean, I got like 700,000 votes in the 2016 election. I dare say more than 50,000 of those people, maybe 100,000, had a concern, if that many, about the raising of money. I think the people who are aware of it are aware that it's an uncomfortable position that we put our judicial candidates in. Because if the candidate wants to run any type of campaign, then he or she has to go out and raise money. And the raising of money is one of the most uncomfortable aspects of this job. I know people who don't hesitate to make the call. I won't make the call. I take what comes in and I leave it at that. But I don't criticize the ones that are able to make the call because they do what they think is right under the circumstances. But there's no question that it's an extremely uncomfortable situation that I don't think any of us would like to continue doing if we didn't have to.
Do you have any thoughts as to the 50,000 out of the 700,000? What types of people are concerned about that? Or is it business? Is it just the average voter? Is it people in the minority community? Do you have any sense of who's concerned about it?
I think it goes across the community. Anybody who's interested in politics, anybody who's interested in the judiciary, and that includes the business community, the legal community, the minority. When I go into the minority communities and go to these clubs and so forth in the Hispanic and African-American communities, there are people in there that are really up to date on what's going on in the courthouse. And so I think everybody is concerned about it. The business community will be concerned about, where I would get my campaign funds from as a Democrat. The other community would be concerned about where a Republican would get their campaign funds from. And so I think it's across the board of those who care about it. They're concerned about the raising of money.
Of those people that are concerned about it, no matter who they are, is it in your estimation, is it a serious concern or just something that, it's something we got to live with?
It kind of depends.
I'm talking about confidence in the judiciary.
I think it kind of depends on the relationship you have with the judiciary. If you're somebody with a case in the court, it's probably a more serious concern that if you're a person, a member of the public who doesn't interact with the courts and just thinks that sounds really dirty.
Great. Thank you so much, Judge. Thanks for appearing. And
Judge, you need to know that had I known that Chip Babcock was going to make his initial remarks, I never would have recognized him to speak.
Well, I think that would have been a mistake because then I wouldn't have been able to appreciate his kind words.
Just one last comment. We've talked about how the public reacts to the judges out there raising money and contributions and so on and so forth. But the fact of the matter is the lawyers are very, very concerned about the very same issue. I mean, let's just take the Texas Supreme Court where you've got several judges that are running for re-election. Well, if you have a case before the Supreme Court and you think the judges are doing a good job, do you make a contribution or do you not make a contribution? Are you concerned that if you make a contribution that somehow that's going to be misperceived? So the lawyers also are in a very difficult position. And at the district bench level, if we get a call from, the finance chair and says, Judge Schaefer is running for re-election, would you be willing to make a contribution? Well, the answer, initially would be of course, but then you think, well, how's this going to be perceived? I don't even know if you even know who the contributions are coming from. But it's just that it's the perception from the lawyers as well as the public that is a problem.
I agree. And I promise you will not get a call from my finance chair because I don't have one. I agree with you completely. And that's why I don't make the calls. But I understand that you're put in a bad spot because if you say no, okay, well, Beck's a jerk, so next time he comes in the courthouse. But I really don't think most of my colleagues act that way. you may have other experiences from me, and I have no firsthand knowledge of it, but I completely get it. And that's the problem with money. And
No, I
money-
agree. And I absolutely agree that I think the overwhelming number of judges don't make decisions based on contributions and so on and so forth. It's just the perception that to me is the problem. Are there any other questions of Judge Schaefer? If not, Judge, thank you so much for taking your time. You've certainly generated a lot of different ideas and thoughts for us to consider, and I appreciate you taking your time to spend with us this morning.
Thank you. I've enjoyed visiting with you folks, and y'all have a great day and be safe out there.
Okay.
Thank you, Judge.
Okay, our next speakers are Peggy Venable and Jeff Oldham. Peggy is the Appointments Director with the Governor's Office, and Jeff Oldham is General Counsel of the Office of the Governor, and they are going to appear jointly to educate us a little bit on the appointment process. And Peggy and Jeff, let me just say that there's been a lot of discussion at our various meetings about the appointment system, and if we decide to make a recommendation along that lines, do we go with an appointment system and the subsequent retention election? And there's been a lot of questions about, well, how the appointments come about. And so I think would be very helpful for the commissioners to learn just exactly what is the appointment process? How does it work? How do you vet potential nominees or candidates to the court? So any guidance you could give us along that line would be most appreciated.
Well, I'm Peggy Venable. I hope you can hear me.
We can.
Very good. Well, thank you so much for inviting us. I have with me Jeff Oldham. I will start the presentation, and we do have a PowerPoint that I would like to share. First, I want to say thank you so much for your service on this commission. And we welcome this opportunity to discuss the process and specifically the judicial appointment process. But I am going to start first with, let's see, hang on just one moment, please. I'm going to go with our slide presentation. Very good. I think we've got it up now. Is this screen? Yes, it is being shared. First, I'll provide you with an overview of the appointments process, the appointments office, and I will apologize in advance to Chairman Birdwell, who knows this process so well and has done such a tremendous job as the nominations chairman. Jeff will later discuss specific aspects that are unique to the judicial appointments. But let's see, first I'll talk about the governor's specific appointment powers, the appointments being one of them. Certainly the governor has the power to set the agenda and to veto, but we really see one of those important powers the governor has as the power to appoint. Let me just say the governor makes about 1,500 appointments per term. The vast majority of these are to boards, commissions, and task forces in which Texans serve at no pay, taking time away from their families, their businesses, and jobs and their community activities. And we're tremendously grateful for the service and sacrifices appointees make as they dedicate their expertise and talent and time to the public. But for paying jobs, it's a little bit easier sometimes to find the applicants. Let me talk first about the appointments office so you have a better idea of who we are and what resources we have here. I'm the director of the office, and we have a deputy director. We also have appointment managers and an appointment coordinator. The appointment managers, myself and the deputy director, each have portfolios of boards which we manage and handle. And we are responsible for knowing those boards inside out, the statutes that created the boards, what constitutes a conflict of interest. Then we're responsible for identifying candidates, sometimes recruiting them, interviewing the candidates, and then recommending individuals to the governor for appointment. I have here a list of our boards and commissions that we appoint to absent the judiciary, but we have all the 400 boards generally divided into 12 generic categories, and we try to assign by appointment manager generic categories. We also have all of our information on an appointments office website. And on that website, we have all of the positions that the governor's office appoints to, as well as the material that we request from appointees, the application itself, and how to contact us with questions. I'm going to turn it over now to Jeff to discuss the authority. Let's see, are we there? I'll turn it over to Jeff. Thank you.
Thank you, Peggy. Okay. Can you hear me?
We can hear you. Thank you.
Great. Thank you, Peggy. We're sharing a room, so we got to get our audio together so we don't have a background. I'll talk a little bit about the governor's appointment authority. And I know I'm talking to a very educated group on this topic, and some of the issues I was going to address have already come up, so I'll go quickly. But I want to hit on four general topics that may be useful in just talking about what the process looks like. So vacancy, the appointment itself, Senate confirmation, and then the term of office. So to the next slide, in talking about vacancies, under the current system, as everyone here knows, there has to be a vacancy before the governor has the authority to make an appointment. The governor does appoint, in addition to non-judicial seats, all of the courts you see there, the Supreme Court of Texas, the Court of Criminal Appeals, and on down. We set forth there some of the basis for which you get resignation, or you get a vacancy, which is death, resignation, removal, eligibility, and then the creation of new courts. And the most common one that leads to vacancies under the current system is, of course, resignations. On to the next slide. Appointments. I've put there some of the basic eligibility requirements. We've talked, so that's come up earlier. I think Judge Schaefer talked about some possible qualification type issues that the commission may look at. And I think, I've just listed there some there, resident of Texas, U.S. citizen, not convicted of a felony. And then for different seats, and depending on the seat, you must meet your age requirement or years of practice type requirement. And then once appointed, it's a term of either 4 or 6 years generally. The next slide talks about confirmation. Senator Burwell raised some of these points earlier, so I won't dwell on it. But obviously, if there is an appointment made during a legislative session, then the Senate would look at confirmation, and the candidate must be confirmed during that session in order to continue in office. Otherwise, at the end of the session, there would be another vacancy. If the judicial appointment is made while the legislature is in recess, then the governor has to nominate that person for confirmation at the next session, except in the scenario that Senator Burwell talked about, which is when there is an intervening general election and then there is no Senate confirmation needed. And that goes to the term of appointment, which is the next slide. And even if there is a Senate confirmation, the appointment to a vacancy only continues in office until the next general election. And then that person would stand for election and would serve only until the next duly elected officer wins the election, either that person on re-election or someone else. So with that, I'll turn it back to Peggy to go over the process for the appointments.
Thank you, Jeff. Let me unmute myself. And I think we're good to go now. Jeff and I are in the same room, so we're going to try to stop that echo here. The appointments office receives applications from judges and attorneys that seek specific appointments. The Judicial Questionnaire and the State Bar Review Form are among the forms that are on our website and are required. Now, many candidates will also have letters of recommendation. Some have very many. Pertinent data is entered into our database, and we keep track of the new courts opening as well as the vacancies. We work with the General Counsel's office, usually directly with Jeff, regarding the which courts we address when. The interviews are with me and the General Counsel and or his deputy General Counsel. We meet to discuss the candidate's qualifications after the interviews, and then recommendations are made to the governor, who makes the final decision. Then the appointments office, of course, is responsible for making that appointment, notifying the candidates certainly first the applicant that's being appointed, and then those that were had also applied. I might make note that there was a question earlier regarding information available to the public. The application and the judicial questionnaire are public documents and can be requested through a PIR. Now the paperwork required for appointment is again highlighted here. Certainly the application, this is the general application that everyone fills out when they want an appointment. It includes a resume and a headshot for it to be complete. The judicial questionnaire, along with the completed state bar and judicial conduct release form, which the appointments office submits to the State Bar of Texas, and for judges or former judges, the Judicial Conduct Commission. The appointment packet can be emailed, mailed, or faxed to us. And a writing requirement is necessary for Supreme Court, Court of Criminal Appeals, and any Court of Appeals. The judicial questionnaire itself is an 8-page document, which again is available on our website. And it asks for professional data, it references, it provides us information on legal education and employment history, questions regarding previous service in the judiciary, and questions regarding any prior legal grievances or disciplinary proceedings. In the process after submission, we first assure that all of the statutory requirements are met for the court that that individual is applying for. And then we evaluate the qualifications and expertise, schedule and conduct candidate interviews. And for those judicial appointments, the appointments office directors assigned, I handle all of the judicial appointments in the office and work very closely with the governor's general counsel in assisting us in ascertaining the qualifications and experience. And in the interview and in the recommendation process itself. Then prior to appointments, the appointments office runs the state bar check for judges and former judges, the judicial conduct check, and we also ask for the Senate concurrence for candidates before appointment. Let's see, the process after submission, the recommendations, of course, are presented to the governor, and the governor selects the candidate. That's when, and as a courtesy, we do ask the senators to concur with their constituent being appointed to that position. Certainly, the governor makes the final decision, and we have a process that we use here in the office for all appointments. The candidates notified, and as our other applicants, the official appointment is made through the Secretary of State's office, and public notification is made through an official press release. I'm going to turn it over to Jeff to kind of wrap up our process.
Jeff, I think you're muted.
Sorry, thank you. Just briefly in closing, Peggy talked earlier about the total number of appointments that the governor has made. And in judicial appointments, the governor has made 93 judicial appointments. This does not include district attorneys, which I think as Senator Birdwell pointed out, the governor also appoints those, but 70 judges appointed to district courts, 20 judges appointed to the intermediate courts of appeals, including 3 chief justice appointments, 3 justices appointed to the Texas Supreme Court, and then also presiding judges of each administrative region. The governor appoints those and has made 14 appointments to the presiding judge position. And so with that, I think that's our last slide in our presentation. Again, thank you for the commissioner for having us here. We'd be happy to answer any questions that the commission may have, but thank you.
This is David Beck. I have a question. In looking at the slide, I noticed that you look into the qualifications of the various candidates, as certainly would be understandable. As you know, the Constitution prescribes what the qualifications are. It's certainly the minimum qualifications. And I guess my question is, I noticed that you asked for writing samples for those that are being considered for appellate benches, Supreme Court bench. But at the trial level, do you all look at such things as number of trials that a candidate may have had before they ever appear on the bench? In other words, do they have no judicial experience? Do they have no trial experience? Anything like that, so that we end up with somebody on the bench who's at least seen a lawsuit tried, even if they haven't actually tried one.
I think those are the kinds of things, absolutely, that candidates would, would put on the application form. As Peggy said, there's both a general application form and then the judicial questionnaire. And the judicial questionnaire, candidates will often put items, like you said, in terms of, best, featured cases or number of cases they tried, things like that. So that's part of what we look for on that judicial questionnaire, is to get answers to more questions like that, so that we can, assess the qualifications, including, as you said, the quality of experience, the years of experience, the type of experience, things like that.
Okay. All right, members of the commission, any questions of Ms. Venable or Mr. Oldham? Senator Birdwell, did you have a question?
No, Mr. Chairman, I would offer one caveat. I would certainly afford Peggy the opportunity to clarify what I'm about to say, but one of in my experience, not just as chair nominations, but with judicial appointments that have occurred in my district, there are appointments that the governor makes to the bench of district judges, but and Governor Perry did the same, that if the vacancy occurs at a time frame where the vacancy on that bench is tolerable, the time frame of that vacancy is tolerable, the governor either waits on the voters to select who's going to be on the ballot, and then the governor follows up and appoints that person after that person's been chosen. As an example, one of my benches in Ellis County was vacated by Judge Grubbs. The governor could have made an appointment, but allows the citizens to determine their candidate. Then once determined, the governor makes them the sitting incumbent. Point of that discussion is the governor defers to the will of the people on those types of appointments where the timing of the vacancy is such that it affords him the ability to defer to the voters in that district. There are some nominations that occur that way, and have been done that way both by Governor Perry and by Governor Abbott.
Chairman, I have a question.
Yes, Judge Jameson.
Thank you. Thank you to Jeff and Peggy for being here. As a gubernatorial appointee to this commission, I obviously think that very wise decisions are made by the appointments office. One thought I had, though, was if this commission gets to sort of the end of its calendar in December and makes a recommendation that involves some sort of commission or other group that would make suggestions to the governor. And I know you can't speak for the governor, but kind of give me the pros and cons of doing sort of a beta test prior to any legislation being passed, to see how such might work with appointments rather than so if a vacancy came up, what are the pros and cons of working with the commission even though you don't have to? Does that make sense?
And you're talking about a system that this commission would be looking at.
Let's presume that this commission makes some recommendations at the end of the day. All right. And people kind of wonder, well, how would that work? I'm just wondering whether, even without being required to, what are the pluses and minuses of testing that, working with a commission or a group of advisors that meet certain parameters? And I'll tell you a little bit more, which is a lot of the criticism that some of the speakers have had about a commission, or no, about a system that ultimately gives authority to the governor, is a worry that if the governor is in the other political party from the speaker, that they would not be given a shot.
Sure.
It
Thank
still
you.
doesn't make sense. My question didn't make sense.
I appreciate the question, and I want to be very careful because obviously we're not here today to express any opinions on what the right, system. This commission is obviously going to look at, the issues of what alternative systems there might be, and the legislature and the people will ultimately decide that. What I can tell you is that, I think we have a process that we believe is a good process in terms of receiving applications and assessing the qualifications, and ultimately the governor making a decision. The governor's office would work closely with, to implement any legislation that the legislature would put into place if a different system were put into place. The only other thing I would add is, as part of our process as it currently stands, we do receive letters of recommendation. We receive, input from people outside of the office who write in, and so there is some element to that already.
And my other question, although I'm still not sure I expressed my first one very well, is who developed the questionnaire and what best practices because that seems to be the enhancement to the statutory and constitutional qualifications for a judge, or what you put in the questionnaire, what you ask for, and the answers that you get. With regarding Chairman Back asked about trial experience and some other things that, as I recall, although it's been 20 years now since I filled out one of those things, there were some questions that were more than, have you been in practice X number of years, and are you over X years of age? So do you know where that came from?
That's correct. I think my understanding is it's changed over time. But I believe the appointments office, though, has put that together in conjunction with the general counsel's office in the past.
Yeah, let me add here that one of the issues, Jeff, that we're struggling with is the qualifications of our judicial candidates. And we're not necessarily talking about appointed people. What we're talking about is candidates generally. The Constitution has a very low threshold, I guess is the best way to put it. So the question to me is, as part of the appointments process, can you require more than what the Constitution has as the minimum? The Constitution may have a years of practice, may have an age, but can you require, as part of the appointments process, even more than that to ensure that the judges that are being appointed are very well qualified?
Sure, I understand. I don't know about whether it would be requiring more qualifications, but certainly as part of receiving the written submissions from candidates and assessing that, we look at all different kinds of qualifications, and I think people have touched on them already in terms of, educational experience, years of experience. As I said earlier, the quality of experience. Does somebody have prior judicial experience? I think all those factors are things that we try to, draw out in the written submissions and then follow up in during interviews. And so certainly, qualifications is the key focus during the process.
Yeah, and require may have been a bad word. Consider is probably a better way to put it.
Sure.
All right, any other questions from any members of the commission? All right, there being none, Peggy and Jeff, thank you so much for taking your time. It's been very educational, and we really appreciate you appearing before us and sharing your thoughts with us. Thank you very much.
Bye-bye.
Thanks, Peggy. Thanks, Jeff.
Thank you.
Okay, our next item on the agenda is the judicial selection survey that we had sent out previously. We actually got the results back by our last meeting, but there really had been no analysis done. We thought we needed some more time to really analyze the results, as opposed to just simply disgorging all of those results to everybody. So Megan, do you want to comment on the results of the survey?
Yes, and I actually do have, so you got the summary of the survey in your materials, but we have a short slide presentation just to kind of guide you. So Kelly, if you'll put that up, perfect. So just to refresh your memory a little bit, the commission developed the questions for this survey back in February and March, and due to the pandemic, we held off on sending it out because people were busy with the pandemic at that time. So the survey actually was sent out in July to the Conference of Chief Justices, which includes every Supreme Court Chief Justice in the country, which Texas Supreme Court Chief Justice Nathan Hecht is currently the president of, and it was also sent to the Conference of State Court Administrators. The survey was made up of 40 questions related to the selection process, including the use of commissions and their opinions regarding the strengths and limitations of their state systems. We received a total of 52 responses to the survey. Many of the answers were open-ended, and about half of the respondents identified themselves and their states. So overall findings, most respondents came from an appointment or mixed appointment and election system. And regardless of which system their state employed, the respondents were largely positive about their state selection process, and no states called for abolishing their current process. As far as judicial qualifications, most respondents believed that their method of judicial selection, irrespective of election or appointment, successfully vetted and seated qualified judges at the trial and appellate court level. And I would say that the most common qualifications that were mentioned were that you had to be a lawyer, live in the state for a certain period of time. Some states like Texas required a certain number of years to be a lawyer. And then some states, their only qualification is that you're learned in the law. I think the most valuable part of the survey were the answers to the open-ended questions, and I hope you all got to read through those. I know there's a lot of them. I want to include a few of the open-ended comments in the presentation. Here's a first set from some of the respondents. I would provide 6-year terms for trial judges and 8 years for appellate judges. That's from Dave Byers from Arizona. Judges serve 4-year terms. Many are unwilling to leave their law practice setting without assurance of more stability. We even hear this for our 6-year terms. I would require a law degree for all judges. All right, moving on to primary appointment bodies. In states where appointment was the primary method of judicial selection, the governor was the primary appointing body for the appellate courts. It was less common for the governor to be primarily responsible for appointing trial court judges. In those cases, judges were either elected or appointed by another body. Appointment systems and confirmation requirements. Respondents from appointment and mixed selection systems were asked to outline selection processes and any confirmation processes required for judges. At both the trial court and appellate court level, according to the responses, a majority of the selected candidates were not subject to a confirmation process, as you can see on the graphs. There's a bipartisan judicial nominating commission that reviews applications and interviews candidates for judicial officer positions. The JNC votes on the candidates and then submits its 3 recommendations to the governor for consideration. This process ensures the candidates are all well qualified. Moreover, at present, Delaware law requires political party balance within the judicial branch, which guarantees that the governor's appointments are not all politically motivated. More on confirmation bodies. In most cases where a candidate was subject to confirmation, that confirmation was conducted by either the Senate or a lower house of the state legislature. In one instance, an executive council was responsible to approve the governor's decision, not the state legislature, and that was actually New Hampshire. Role of commissions. In responses where a governor's appointment did not require confirmation, the use of commissions to vet and provide qualified candidates was universal. 83% of all respondents indicated that their system employed the use of commissions at some point in the judicial selection process for both trial and appellate court positions. 91% of respondents indicated that the commissions work well in selecting and identifying qualified candidates. Moving on to the comments. The key is the nonpartisan judicial nominating commissions that screen all applicants and send 2 names to the governor from which he or she must pick. This approach yields better qualified nominees with less political influence. That's from Todd Nucio in Iowa. I like the system we follow. I understand the concern of states where judges are elected is primarily that Main Street should have a say in who becomes a judge. But I think there's greater success we have seen since our Constitution was changed in the mid-1970s to adopt the current model for selecting judges. Our system of qualification and appointment has created better assurance that we seat people who are well qualified and are models of balance, intellect, and wisdom to the people we serve. And that's from Paul Reber in Vermont. Moving on to campaign finance and partisan elections, respondents from partisan election states did express reservations about campaign finance, as you can see in the graphs. Respondents specifically from Pennsylvania and Nevada expressed concern about outside campaign influences and proposed changing their systems to cap private donor spending or limiting spending to public systems. In one instance, a respondent advocated for the removal of partisan elections altogether. And in Oklahoma, the respondent advocated for nonpartisan elections as a way to cut through the politicking. Moving on to the comments. In Idaho, we have nonpartisan WINK elections for general jurisdiction and appellate positions. However, the Judicial Council fills the positions for death, disability, or retirement by interviewing all candidates. Then it sends 2 to 4 candidates to the governor, who must pick from that group. The governor's decision is final. The most important trend is that our retiring judges retire in time to let the Judicial Council and governor to work their magic. I would venture a guess that about 90% or more of these judges and justices retire early because they believe in this merit system. That's from Robert Burdick in Idaho. Ballot and voter information. As most states were either appointment or mixed appointment and retention election, many respondents did not indicate that their state provided voters with any specific information regarding judicial candidates. In those states that did, indicators of the incumbency status of the candidate on the ballot was discussed. You can see that 47% of those surveyed said that they include that by either putting incumbent on the ballot or listing it as Judge John Smith. In addition to incumbent status, other methods mentioned include pamphlets provided by the state at polling places, candidate information materials provided by political parties, and position papers by advocacy groups. In Alaska, the Judicial Council provides an evaluation pamphlet for every candidate up for a retention election. While the information the Selection Commission receives helps them make the best choices, regular voters have no such information available to them at election time. I would like to have all judges and judicial candidates respond to 10 to 15 question application so that the qualifications and knowledge could be compared. That's from Robin Sweet in Nevada. Online video and printed voter guides was one of the suggestions from Chief Justice Deborah Stevens in Washington State. And then performance commissions gather information and prepare a summary and recommendation that is published, along with pros and cons of popular initiatives appearing on the ballot. And that's from Nathan Coates in Colorado. So I want to add to that, in addition to the analysis that we did, the Public Policy Research Institute is also going to be doing a deep dive and including a report on this survey for y'all's report. And that's my conclusion of my presentation. I'm happy to answer any questions you have.
You know, Megan, this is David. It looks to me like basically people like the system that they had. And whatever nuances their system had, they just liked it because that's what they've been doing. I mean, is that essentially correct?
Yes, and that's kind of, why we wanted to delay presenting this at the last meeting because we wanted to do a deeper dive. And I think doing a deeper dive by looking at the comments will be the most helpful to the commission. But yes, I mean, 97% said they liked the system that they had. And, half of the respondents did identify themselves and the other half didn't. So I don't know if because those that identified themselves, maybe they weren't as forthcoming, but so that's also something to consider.
And I know we sent out over 100 requests to participate in the survey. I don't know how many responses we got back, but are we convinced that we did in fact receive a reliable return on our request for information?
I think so, because we didn't get a lot of double responses, and so we got 52 responses. So I think most states are covered by this survey.
Yeah,
So
that's over 50%, which is pretty good.
right.
All right, any questions of Megan about the survey that we did?
David, I've just got one question, if I may.
Go ahead.
Megan, you say that everybody was satisfied with their system. Did we survey any state that had a system like ours?
Yes.
Which ones?
We surveyed all of them. So we sent it to so that CCJ has the Supreme Court Chief Justice from every state, and then it was sent to every state court administrator.
Right.
So it went to every state in our nation.
But you said that we got what, 50 some odd responses.
52.
52 responses, but did any of those responses come from a state that have a system like ours where they said, yeah, we're totally fine and happy with how things are going?
Yes. And we can break those out. It might be in the annex document that we sent you, the summary document, but if not, I can break that out and send you specifically the responses from the partisan election states.
Okay. Thanks.
All right, any other questions of Megan? All right, thank you, Megan, for your presentation of the survey results. Been very, very helpful, so I thank you. Under new items, new matters on our agenda, you were sent out earlier this week an outline of our final report. And what I wanted to do is to give you some idea of what the outline is of the various subdivisions are of our report. And the Texas Public Policy Institute at Texas A&M that we talked to earlier is already working on this. And basically what they're doing is dealing with the history, the factual history. Our real discussion is going to come under item 8, which is what our recommendations are going to be to the legislature. We're not there yet. And we've got several more meetings. We've got some public hearings where we need to have input. But I did want you to know just basically what the outline is of what I believe our report is likely to be. Doesn't mean we can't change it. We can change it. If you've got any additions, subtractions, we can certainly do that. But I just wanted to give you some idea at this point of where what the outline of our report may well be. So those are all of the matters that I had. Megan, is there anything else that we needed to tell the members of the commission before we, excuse me, Representative Hunter?
Let me make a constructive comment and feedback. If you've noticed, you didn't hear from one House member today. And let me just kind of throw this out. Our friends on the Senate, we respect, but as one of the most senior members, you know, when we talk about judicial selection, we don't have to look at the current system. The current system of today's meeting was basically Senate confirmation and appointment process. I would encourage on future meetings that we involve the House as well. Also, there's nothing that prohibits us to look at a commission where the House has input into appointments. And so I don't mean this negative, I don't mean this critical, but we all kind of get in to the same box and we need to think outside the box on judicial selection. I always tell everybody, don't forget, it takes the House and the Senate to vote on the budget, not just one body. So my suggestion is, Mr. Chairman and everybody, let's kind of make sure that we got both legislative bodies involved, because sometimes it's coming off that we're just looking at, and I'm not criticizing the current system because that's what it is. But I do want to encourage let's look at a way where the Texas House of Representatives has some input into whatever concepts we're looking at. So I suggest that in nothing negative or critical, but as to think outside the box as we move forward. Because when you go to the recommendations, we may have different ideas on who has input onto who on the commission. So I use that just as a constructive observation and not a criticism.
Thank you, Representative Hunter. Excellent point, and we will certainly do that. All right, any other comments, or Megan, did you have something you wanted to add?
And I just wanted to remind y'all of the hearing on Tuesday, the public hearing focused on the San Antonio area. We have, I think 12 registered so far. Registration is going to close for testimony on Monday at 5. The San Antonio Bar Association also sent out a survey to all their members and has received a lot of feedback. And so the bar president's going to make a presentation at that hearing as well. So if you have anyone that you know that wants to testify, please.
Yeah, and with respect to the San Antonio Bar Association survey, the president has asked for a few more minutes than our customary time limit, and we have granted him that. I thought it might be helpful to the commission if we did in fact have an opportunity to hear all about the survey and what the findings of the survey are. So thanks, Megan, for reminding everybody about our public hearing. Any other comments or suggestions by any members of the commission?
Mr. Chair.
Yes, Mr. Oliveros.
Good morning. I was wondering if we could get the results of that survey, because I actually had a couple of San Antonio judges call me last week, did a Zoom meeting with me to discuss this issue, and they said that, they told me the survey was overwhelmingly against any kind of merit selection, and so I kind of wanted to see it, hope to see it before the meeting on Tuesday, the hearing on Tuesday.
You're talking about the San Antonio Bar Association survey?
That's correct.
Okay, Megan, why don't we see if we can get a copy of that survey and get it to all the members of the commission as quickly as we can, but certainly before the Tuesday meeting.
Yeah, I think it was closing today, but I will ask them for it and see if they can get it to us by Monday.
She also made reference.
I was going to say that'll give us all a little opportunity to study it and may precipitate some questions we might have.
She also made reference to a state bar survey. I hadn't seen one. Has anybody heard of the State Bar of Texas surveying its members?
I think maybe what they're talking about is the appellate section of the State Bar did that survey, and they presented the results, I think at the July meeting. But I haven't heard of the bar doing any other.
I hadn't either, but if we can see those results as well, I'm curious to see how they came out.
Yeah, no, I'm not aware of any state bar survey, but Megan is exactly right. The appellate section of the state bar did do a survey, which I believe we discussed at our July meeting, but we'll certainly provide you with a copy of that as well, David.
Thank you.
All right, any other comments or suggestions or questions by any members of the commission?
I do have one other thing very quickly, just to answer Chip's question about what partisan states responded to the survey and identified themselves. And it was Tennessee, Pennsylvania, Alabama, and Illinois. And we'll get you those results. They're direct results to you too.
All right, there being nothing further to come before the commission today, our meeting is adjourned. Thank you all very much for participating today.
Thank you, Mr. Chairman.
Thank you, David.